Rule 11. When to file responsive pleadings. Section 1. Answer to the complaint. The defendant shall file his answer to the complaint within 15 days after service of summons, unless a different period is fixed by the court. Law. Section 2. Answer of a defendant foreign private juridical entity. Where the defendant is a foreign private juridical entity and service of summons is made on the government official designated by law to receive the same, the answer shall be filed within 30 days after receipt of summons by such entity. 2a. Section 3. Answer to amended complaint. When the plaintiff files an amended complaint as a matter of right, the defendant shall answer the same within 15 days after being served with a copy thereof. Where its filing is not a matter of right, the defendant shall answer the amended complaint within 10 days from notice of the order admitting the same. An answer earlier filed may serve as the answer to the amended complaint if no new answer is filed. This rule shall apply to the answer to an amended counterclaim, amended cross-claim, amended third, fourth, etc. Party complaint, and amended complaint in intervention. 3a. Section 4. Answer to counterclaim or cross-claim. A counterclaim or cross-claim must be answered within 10 days from service. 4. Section 5. Answer to third, fourth, etc. Party complaint. The time to answer a third, fourth, etc. Party complaint shall be governed by the same rule as the answer to the complaint. 5a. Section 6. Reply. A reply may be filed within 10 days from service of the pleading responded to. 6. Section 7. Answer to supplemental complaint. A supplemental complaint may be answered within 10 days from notice of the order admitting the same, unless a different period is fixed by the court. The answer to the complaint shall serve as the answer to the supplemental complaint if no new or supplemental answer is filed. N. Section 8. Existing counterclaim or cross-claim. A compulsory counterclaim or a cross-claim that a defending party has at the time he files his answer shall be contained therein. 8a, R6. Section 9. Counterclaim or cross-claim arising after answer. A counterclaim or a cross-claim which either matured or was acquired by a party after serving his pleading may, with the permission of the court, be presented as a counterclaim or a cross-claim by supplemental pleading before judgment. 9, R6. Section 10. Omitted counterclaim or cross-claim. When a pleader fails to set up a counterclaim or a cross-claim through oversight, inadvertence, or excusable neglect, or when justice requires, he may, by leave of court, set up the counterclaim or cross-claim by amendment before judgment. 3, R9. Section 11. Extension of time to plead. Upon motion and on such terms as may be just, the court may extend the time to plead provided in these rules. The court may also, upon like terms, allow an answer or other pleading to be filed after the time fixed by these rules. 7. Rule 12. Bill of Particulars. Section 1. When applied for purpose. Before responding to a pleading, a party may move for a definite statement or for a bill of particulars of any matter which is not averted with sufficient definiteness or particularity to enable him properly to prepare his responsive pleading. If the pleading is a reply, the motion must be filed within 10 days from service thereof. Such motion shall point out the defects complained of, the paragraphs wherein they are contained, and the details desired. 1a. Section 2. Action by the court. Upon the filing of the motion, the clerk of court must immediately bring it to the attention of the court, which may either deny or grant it outright, or allow the parties the opportunity to be heard. N. Section 3. Compliance with order. If the motion is granted, either in whole or in part, the compliance therewith must be effected within 10 days from notice of the order, unless a different period is fixed by the court. The bill of particulars or a more definite statement ordered by the court may be filed either in a separate or in an amended pleading, serving a copy thereof on the adverse party. N. Section 4. Effect of non-compliance. If the order is not obeyed, or in case of insufficient compliance therewith, the court may order the striking out of the pleading or the portions thereof to which the order was directed, or make such other order as it deems just. 1 Ca. Section 5. Stay of period to file responsive pleading. After service of the bill of particulars or of a more definite pleading, or after notice of denial of his motion, the moving party may file his responsive pleading within the period to which he was entitled at the time of filing his motion, which shall not be less than 5 days in any event. 1ba. Section 6. Bill a part of pleading. A bill of particulars becomes part of the pleading for which it is intended. 1aa. Rule 13. Filing and service of pleadings, judgments, and other papers. Section 1. Coverage. This rule shall govern the filing of all pleadings and other papers, as well as the service thereof, except those for which a different mode of service is prescribed. N. Section 2. Filing and service, defined. Filing is the act of presenting the pleading or other paper to the clerk of court. Service is the act of providing a party with a copy of the pleading or paper concerned. If any party has appeared by counsel, service upon him shall be made upon his counsel or one of them, unless service upon the party himself is ordered by the court. Where one counsel appears for several parties, he shall only be entitled to one copy of any paper served upon him by the opposite side. 2a. Section 3. Manner of filing. The filing of pleadings, appearances, motions, notices, orders, judgments and all other papers shall be made by presenting the original copies thereof, plainly indicated as such, personally to the clerk of court or by sending them by registered mail. In the first case, the clerk of court shall endorse on the pleading the date and hour of filing. In the second case, the date of the mailing of motions, pleadings, or any other papers or payments or deposits, as shown by the post office stamp on the envelope or the registry receipt, shall be considered as the date of their filing, payment, or deposit in court. The envelope shall be attached to the record of the case. 1a. Section 4. Papers required to be filed and served. Every judgment, resolution, order, pleading subsequent to the complaint, written motion, notice, appearance, demand, offer of judgment or similar papers shall be filed with the court, and served upon the parties affected. 2a. Section 5. Modes of service. Service of pleadings, motions, notices, orders, judgments and other papers shall be made either personally or by mail. 3a. Section 6. Personal service. Service of the papers may be made by delivering personally a copy to the party or his counsel, or by leaving it in his office with his clerk or with a person having charge thereof. If no person is found in his office, or his office is not known, or he has no office, then by leaving the copy, between the hours of 8 in the morning and 6 in the evening, at the party's or counsel's residence, if known, with a person of sufficient age and discretion then residing therein. 4a. Section 7. Service by mail. Service by registered mail shall be made by depositing the copy in the post office in a sealed envelope, plainly addressed to the party or his counsel at his office, if known, otherwise at his residence, if known, with postage fully prepaid, and with instructions to the postmaster to return the mail to the sender after 10 days if undelivered. If no registry service is available in the locality of either the senders or the addressee, service may be done by ordinary mail. 5a. Bar Matter Number 803, February 17, 1998. Section 8. Substituted service. If service of pleadings, motions, notices, resolutions, orders and other papers cannot be made under the two preceding sections, the office and place of residence of the party or his counsel being unknown. Service may be made by delivering the copy to the clerk of court, with proof of failure of both personal service and service by mail. The service is complete at the time of such delivery. 6a. Section 9. Service of judgments, final orders, or resolutions. Judgments, final orders, or resolutions shall be served either personally or by registered mail. When a party summoned by publication has failed to appear in the action, judgments, final orders, or resolutions against him shall be served upon him also by publication at the expense of the prevailing party. 7a. Section 10. Completeness of service. Personal service is complete upon actual delivery. Service by ordinary mail is complete upon the expiration of 10 days after mailing, unless the court otherwise provides. Service by registered mail is complete upon actual receipt by the addressee, or after 5 days from the date he received the first notice of the postmaster, whichever date is earlier. 8a. Section 11. Priorities in modes of service and filing. Whenever practicable, the service and filing of pleadings and other papers shall be done personally. Except with respect to papers emanating from the court, a resort to other modes must be accompanied by a written explanation why the service or filing was not done personally. A violation of this rule may be cause to consider the paper as not filed. N. Section 12. Proof of filing. The filing of a pleading or paper shall be proved by its existence in the record of the case. If it is not in the record, but is claimed to have been filed personally, the filing shall be proved by the written or stamped acknowledgement of its filing by the clerk of court on a copy of the same, if filed by registered mail, by the registry receipt and by the affidavit of the person who did the mailing, containing a full statement of the date and place of depositing the mail in the post office in a sealed envelope addressed to the court, with postage fully prepaid, and with instructions to the postmaster to return the mail to the sender after 10 days if not delivered. N. Section 13. Proof of service. Proof of personal service shall consist of a written admission of the party served, or the official return of the server, or the affidavit of the party serving, containing a full statement of the date, place, and manner of service. If the service is by ordinary mail, proof thereof shall consist of an affidavit of the person mailing of facts showing compliance with Section 7 of this rule. If service is made by registered mail, proof shall be made by such affidavit and the registry receipt issued by the mailing office. The registry return card shall be filed immediately upon its receipt by the sender, or in lieu thereof the unclaimed letter together with the certified or sworn copy of the notice given by the postmaster to the addressee. 10a. Section 14. Notice of lis pendens. In an action affecting the title or the right of possession of real property, the plaintiff, and the defendant, when affirmative relief is claimed in his answer, may record in the office of the Registry of Deeds of the province in which the property is situated notice of the pendency of the action. Said notice shall contain the names of the parties and the object of the action or defense, and a description of the property in that province affected thereby. Only from the time of filing such notice for record shall a purchaser, or encumbrancer of the property affected thereby, be deemed to have constructive notice of the pendency of the action, and only of its pendency against the parties designated by their real names. The notice of lis pendens herein above mentioned may be cancelled only upon order of the court, after proper showing that the notice is for the purpose of molesting the adverse party, or that it is not necessary to protect the rights of the party who caused it to be recorded. 24a, R14. Rule 14. Summons. Section 1. Clerk to issue summons. Upon the filing of the complaint and the payment of the requisite legal fees, the clerk of court shall forthwith issue the corresponding summons to the defendants. 1a. Section 2. Contents. The summons shall be directed to the defendant, signed by the clerk of court under seal and contain, a. the name of the court and the names of the parties to the action, b. a direction that the defendant answer within the time fixed by these rules. C. A notice that unless the defendant so answers, plaintiff will take judgment by default and may be granted the relief applied for. A copy of the complaint and order for appointment of guardian ad litem, if any, shall be attached to the original and each copy of the summons. 3a. Section 3. By whom served. The summons may be served by the sheriff, his deputy, or other proper court officer, or for justifiable reasons by any suitable person authorized by the court issuing the summons. 5a. Section 4. Return. When the service has been completed, the server shall, within 5 days therefrom, serve a copy of the return, personally or by registered mail, to the plaintiff's counsel, and shall return the summons to the clerk, who issued it, accompanied by proof of service. 6a. Section 5. Issuance of alias summons. If a summons is returned without being served on any or all of the defendants, the server shall also serve a copy of the return on the plaintiff's counsel, stating the reasons for the failure of service, within 5 days therefrom. In such a case, or if the summons has been lost, the clerk, on demand of the plaintiff, may issue an alias summons. 4a. Section 6. Service in person on defendant. Whenever practicable, the summons shall be served by handling a copy thereof to the defendant in person, or, if he refuses to receive and sign for it, by tendering it to him. 7a. Section 7. Substituted service. If, for justifiable causes, the defendant cannot be served within a reasonable time as provided in the preceding section, service may be effected, a. by leaving copies of the summons at the defendant's residence with some person of suitable age and discretion then residing therein, or, b. by leaving the copies at defendant's office or regular place of business with some competent person in charge thereof. 8a. Section 8. Service upon entity without juridical personality. When persons associated in an entity without juridical personality are sued under the name by which they are generally or commonly known, service may be effected upon all the defendants by serving upon any one of them, or upon the person in charge of the office or place of business maintained in such name. But such service shall not bind individually any person whose connection with the entity has, upon due notice, been severed before the action was brought. 9a. Section 9. Service upon prisoners. When the defendant is a prisoner confined in a jail or institution, service shall be effected upon him by the officer having the management of such jail or institution who is deemed deputized as a special sheriff for said purpose. 12a. Section 10. Service upon minors and incompetents. When the defendant is a minor, insane, or otherwise an incompetent, service shall be made upon him personally and on his legal guardian if he has one, or if none his guardian ad litem whose appointment shall be applied for by the plaintiff. In the case of a minor, service may also be made on his father or mother. L0a, 11a. Section 11. Service upon domestic private juridical entity. When the defendant is a corporation, partnership, or association organized under the laws of the Philippines with a juridical personality, service may be made on the president, managing partner, general manager, corporate secretary, treasurer, or in-house counsel. 13a. Section 12. Service upon foreign private juridical entities. When the defendant is a foreign private juridical entity which has transacted business in the Philippines, service may be made on its resident agent designated in accordance with law for that purpose, or, if there be no such agent, on the government official designated by law to that effect, or on any of its officers or agents within the Philippines. 14a. Section 13. Service upon public corporations. When the defendant is the Republic of the Philippines, service may be effected on the Solicitor General, in case of a province, city, or municipality, or like public corporations, service may be effected on its executive head, or on such other officer or officers as the law or the court may direct. 15. Section 14. Service upon defendant whose identity or whereabouts are unknown. In any action where the defendant is designated as an unknown owner, or the like, or whenever his whereabouts are unknown and cannot be ascertained by diligent inquiry, service may, by leave of court, be effected upon him by publication in a newspaper of general circulation and in such places and for such time as the court may order. 16a. Section 15. Extraterritorial service. When the defendant does not reside and is not found in the Philippines, and the action affects the personal status of the plaintiff or relates to, or the subject of which is, property within the Philippines, in which the defendant has or claims a lien or interest, actual or contingent, or in which the relief demanded consists, wholly or in part, in excluding the defendant from any interest therein, or the property of the defendant has been attached within the Philippines, service may, by leave of court, be effected out of the Philippines by personal service as under Section 6, or by publication in a newspaper of general circulation in such places and for such time as the court may order, in which case a copy of the summons and order of the court shall be sent by registered mail to the last known address of the defendant, or in any other manner the court may deem sufficient. Any order granting such leave shall specify a reasonable time, which shall not be less than 60 days after notice, within which the defendant must answer. 17a. Section 16. Residence temporarily out of the Philippines. When any action is commenced against a defendant who ordinarily resides within the Philippines, but who is temporarily out of it, service may, by leave of court, be also effected out of the Philippines, as under the preceding section. 18a. Section 17. Leave of court. Any application to the court under this rule for leave to effect service in any manner for which leave of court is necessary shall be made by motion in writing, supported by affidavit of the plaintiff or some person on his behalf, setting forth the grounds for the application. 19. Section 18. Proof of service. The proof of service of a summons shall be made in writing by the server and shall set forth the manner, place, and date of service, shall specify any papers which have been served with the process and the name of the person who received the same, and shall be sworn to when made by a person other than a sheriff or his deputy. 20. Section 19. Proof of service by publication. If the service has been made by publication, service may be proved by the affidavit of the printer, his foreman, or principal clerk, or of the editor, business, or advertising manager, to which affidavit a copy of the publication shall be attached, and by an affidavit showing the deposit of a copy of the summons and order for publication in the post office, postage prepaid, directed to the defendant by registered mail to his last known address. 21. Section 20. Voluntary appearance. The defendant's voluntary appearance in the action shall be equivalent to service of summons. The inclusion in a motion to dismiss of other grounds aside from lack of jurisdiction over the person of the defendant shall not be deemed a voluntary appearance. 23a. Rule 15. Motions. Section 1. Motion defined. A motion is an application for relief other than by a pleading. 1a. Section 2. Motions must be in writings. All motions shall be in writing except those made in open court or in the course of a hearing or trial. 2a. Section 3. Contents. A motion shall state the relief sought to be obtained and the grounds upon which it is based, and if required by these rules or necessary to prove facts alleged therein, shall be accompanied by supporting affidavits and other papers. 3a. Section 4. Hearing of motion. Except for motions which the court may act upon without prejudicing the rights of the adverse party, every written motion shall be set for hearing by the applicant. Every written motion required to be heard and the notice of the hearing thereof shall be served in such a manner as to ensure its receipt by the other party at least 3 days before the date of hearing, unless the court for good cause sets the hearing on shorter notice. 4a. Section 5. Notice of hearing. The notice of hearing shall be addressed to all parties concerned, and shall specify the time and date of the hearing, which must not be later than 10 days after the filing of the motion. 5a. Section 6. Proof of service necessary. No written motion set for hearing shall be acted upon by the court without proof of service thereof. 6a. Section 7. Motion day. Except for motions requiring immediate action, all motions shall be scheduled for hearing on Friday afternoons, or if Friday is a non-working day, in the afternoon of the next working day. 7a. Section 8. Omnibus motion. Subject to the provisions of Section 1 of Rule 9, a motion attacking a pleading, order, judgment, or proceeding shall include all objections then available, and all objections not so included shall be deemed waived. 8a. Section 9. Motion for leave. A motion for leave to file a pleading or motion shall be accompanied by the pleading or motion sought to be admitted. N. Section 10. Form. The rules applicable to pleadings shall apply to written motions so far as concerns caption, designation, signature, and other matters of form. 9a. Rule 16. Motion to dismiss. Section 1. Grounds. Within the time for but before filing the answer to the complaint or pleading asserting a claim, a motion to dismiss may be made on any of the following grounds. A. That the court has no jurisdiction over the person of the defending party. B. That the court has no jurisdiction over the subject matter of the claim. C. That venue is improperly laid. D. That the plaintiff has no legal capacity to sue. E. That there is another action pending between the same parties for the same cause. F. That the cause of action is barred by a prior judgment or by the statute of limitations. G. That the pleading asserting the claim states no cause of action. H. That the claim or demand set forth in the plaintiff's pleading has been paid, waived, abandoned, or otherwise extinguished. I. That the claim on which the action is founded is enforceable under the provisions of the statute of frauds, and J. That a condition precedent for filing the claim has not been complied with. 1a. Section 2. Hearing of motion. At the hearing of the motion, the parties shall submit their arguments on the questions of law and their evidence on the questions of fact involved except those not available at that time. Should the case go to trial, the evidence presented during the hearing shall automatically be part of the evidence of the party presenting the same. N. Section 3. Resolution of motion. After the hearing, the court may dismiss the action or claim, deny the motion, or order the amendment of the pleading. The court shall not defer the resolution of the motion for the reason that the ground relied upon is not indubitable. In every case, the resolution shall state clearly and distinctly the reasons therefor. 3a. Section 4. Time to plead. If the motion is denied, the movant shall file his answer within the balance of the period prescribed by Rule 11 to which he was entitled at the time of serving his motion, but not less than 5 days in any event, computed from his receipt of the notice of the denial. If the pleading is ordered to be amended, he shall file his answer within the period prescribed by Rule 11 counted from service of the amended pleading, unless the court provides a longer period. 4a. Section 5. Effect of dismissal. Subject to the right of appeal, an order granting a motion to dismiss based on paragraphs F, H, and I of Section 1 hereof shall bar the refiling of the same action or claim. N. Section 6. Pleading grounds as affirmative defenses. If no motion to dismiss has been filed, any of the grounds for dismissal provided for in this rule may be pleaded as an affirmative defense in the answer and, in the discretion of the court, a preliminary hearing may be had thereon as if a motion to dismiss had been filed. 5a. The dismissal of the complaint under this section shall be without prejudice to the prosecution in the same or separate action of a counterclaim pleaded in the answer. N. Rule 17. Dismissal of actions. Section 1. Dismissal upon notice by plaintiff. A complaint may be dismissed by the plaintiff by filing a notice of dismissal at any time before service of the answer or of a motion for summary judgment. Upon such notice being filed, the court shall issue an order confirming the dismissal. Unless otherwise stated in the notice, the dismissal is without prejudice, except that a notice operates as an adjudication upon the merits when filed by a plaintiff who has once dismissed in a competent court an action based on or including the same claim. 1a. Section 2. Dismissal upon motion of plaintiff. Except as provided in the preceding section, a complaint shall not be dismissed at the plaintiff's instance save upon approval of the court and upon such terms and conditions as the court deems proper. If a counterclaim has been pleaded by a defendant prior to the service upon him of the plaintiff's motion for dismissal, the dismissal shall be limited to the complaint. The dismissal shall be without prejudice to the right of the defendant to prosecute his counterclaim in a separate action unless within 15 days from notice of the motion he manifests his preference to have his counterclaim resolved in the same action. Unless otherwise specified in the order, a dismissal under this paragraph shall be without prejudice. A class suit shall not be dismissed or compromised without the approval of the court. 2a. Section 3. Dismissal due to fault of plaintiff. If, for no justifiable cause, the plaintiff fails to appear on the date of the presentation of his evidence in chief on the complaint, or to prosecute his action for an unreasonable length of time, or to comply with these rules or any order of the court, the complaint may be dismissed upon motion of the defendant or upon the court's own motion, without prejudice to the right of the defendant to prosecute his counterclaim in the same or in a separate action. This dismissal shall have the effect of an adjudication upon the merits, unless otherwise declared by the court. 3a. Section 4. Dismissal of counterclaim, cross-claim, or third-party complaint. The provisions of this rule shall apply to the dismissal of any counterclaim, cross-claim, or third-party complaint. A voluntary dismissal by the claimant by notice as in Section 1 of this rule, shall be made before a responsive pleading or a motion for summary judgment is served or, if there is none, before the introduction of evidence at the trial or hearing. 4a. Rule 18. Pre-trial. Section 1. When conducted. After the last pleading has been served and filed, if shall be the duty of the plaintiff to promptly move ex parte that the case be set for pre-trial. 5a, R20. Section 2. Nature and purpose. The pre-trial is mandatory. The court shall consider a. The possibility of an amicable settlement or of a submission to alternative modes of dispute resolution. b. The simplification of the issues. c. The necessity or desirability of amendments to the pleadings. d. The possibility of obtaining stipulations or admissions of facts and of documents to avoid unnecessary proof. e. The limitation of the number of witnesses. f. The advisability of a preliminary reference of issues to a commissioner. g. The propriety of rendering judgment on the pleadings, or summary judgment, or of dismissing the action should a valid ground therefore be found to exist. h. The advisability or necessity of suspending the proceedings, and I. Such other matters as may aid in the prompt disposition of the action. 1a, R20. Section 3. Notice of pre-trial. The notice of pre-trial shall be served on counsel, or on the party who has no counsel. The counsel served with such notice is charged with the duty of notifying the party represented by him. N. Section 4. Appearance of parties. It shall be the duty of the parties and their counsel to appear at the pre-trial. The non-appearance of a party may be excused only if a valid cause is shown therefor or if a representative shall appear in his behalf fully authorized in writing to enter into an amicable settlement, to submit to alternative modes of dispute resolution, and to enter into stipulations or admissions of facts and of documents. N. Section 5. Effect of failure to appear. The failure of the plaintiff to appear when so required pursuant to the next preceding section shall be cause for dismissal of the action. The dismissal shall be with prejudice, unless otherwise ordered by the court. A similar failure on the part of the defendant shall be cause to allow the plaintiff to present his evidence ex parte and the court to render judgment on the basis thereof. 2a. R20. Section 6. Pretrial brief. The parties shall file with the court and serve on the adverse party, in such manner as shall ensure their receipt thereof at least 3 days before the date of the pretrial, their respective pretrial briefs, which shall contain, among others, a statement of their willingness to enter into amicable settlement or alternative modes of dispute resolution, indicating the desired terms thereof. b. A summary of admitted facts and proposed stipulation of facts. c. The issues to be tried or resolved. d. The documents or exhibits to be presented stating the purpose thereof. e. A manifestation of their having availed or their intention to avail themselves of discovery procedures or referral to commissioners, and f. The number and names of the witnesses, and the substance of their respective testimonies. Failure to file the pretrial brief shall have the same effect as failure to appear at the pretrial. N. Section 7. Record of pretrial. The proceedings in the pretrial shall be recorded. Upon the termination thereof, the court shall issue an order which shall recite in detail the matters taken up in the conference, the action taken thereon, the amendments allowed to the pleadings, and the agreements or admissions made by the parties as to any of the matters considered. Should the action proceed to trial, the order shall explicitly define and limit the issues to be tried. The contents of the order shall control the subsequent course of the action, unless modified before trial to prevent manifest injustice. 5a. R20. Rule 19. Intervention. Section 1. Who may intervene? A person who has a legal interest in the matter in litigation, or in the success of either of the parties, or an interest against both, or is so situated as to be adversely affected by a distribution or other disposition of property in the custody of the court or of an officer thereof may, with leave of court, be allowed to intervene in the action. The court shall consider whether or not the intervention will unduly delay or prejudice the adjudication of the rights of the original parties, and whether or not the intervener's rights may be fully protected in a separate proceeding. 2a. B.A. R12. Section 2. Time to intervene. The motion to intervene may be filed at any time before rendition of judgment by the trial court. A copy of the pleading in intervention shall be attached to the motion and served on the original parties. N. Section 3. Pleadings in intervention. The intervener shall file a complaint in intervention if he asserts a claim against either or all of the original parties, or an answer in intervention if he unites with the defending party in resisting a claim against the latter. 2ca. R12. Section 4. Answer to complaint in intervention. The answer to the complaint in intervention shall be filed within 15 days from notice of the order admitting the same, unless a different period is fixed by the court. 2da. R12. Rule 20. Calendar of cases. Section 1. Calendar of cases. The clerk of court, under the direct supervision of the judge, shall keep a calendar of cases for pre-trial, for trial, those whose trials were adjourned or postponed, and those with motions to set for hearing. Preference shall be given to habeas corpus cases, election cases, special civil actions, and those so required by law. 1a. R22. Section 2. Assignment of cases. The assignment of cases to the different branches of a court shall be done exclusively by raffle. The assignment shall be done in open session, of which adequate notice shall be given so as to afford interested parties the opportunity to be present.